Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. Welcome back to the Labour Justice Barometer. Today we are on episode 2, and we have a very distinguished guest joining us, which is Mario Jacobs, who is a researcher and lecturer at CENTROW. With over 24 years as a trade union official, Mario has actually been at the forefront of advocating for workers' rights, deeply involved in research related to labour law and labour market developments. His extensive background and insights make him a valuable voice in our discussions today on labour justice. Mario, it's a pleasure to have you with us today.
It certainly is my pleasure, and thank you for inviting me.
We're going to be discussing the InArthur versus RTT award. This was an arbitration award. The primary issue was whether InArthur was an employee of the RTT Group. To give you a bit of a background on what was the issue, was InArthur was employed by the respondent, who is RTT, as a driver to make deliveries for supermarket chains when orders were placed online. So think of your average pick and pay driver, Checkers 60 driver, think of that. When his services were terminated, he referred a dispute to the CCMA, claiming that he had been unfairly dismissed. RTT raised a point during the conciliation that InArthur was not in fact an employee, but an independent contractor. This question of whether he's an employee or an independent contractor had to be taken into account, and whether the CCMA actually had the jurisdiction to entertain InArthur's unfair dismissal claim. Now, Mario, tell me, what are your initial thoughts on the InArthur RTT case? Do you agree with this? Because the decision in this case, the CCMA ruled in favor of the RTT Group, and they found that InArthur was not an employee, but actually an independent contractor. And the decision was based on the nature of his work arrangement and the terms of his contract, which classified him as an independent contractor.
The InArthur versus RTT arbitration award clearly illustrates the many hurdles platform workers face when challenging a claim of unfair dismissal at the CCMA. In the first instance, the worker is not allowed any representation as he is deemed not to be an employee, and because of that, not able to join a trade union for the purpose of representation at the CCMA. The employer, as the arbitration would clearly indicate, was represented by an official from the employer's organization. Secondly, if the commissioner correctly applied the presumption in Section 200A of the Labour Relations Act, along with the common law dominant impression test, it might have concluded that a 6060 driver could be presumed to be an employee rather than an independent contractor. This finding would have established the CCMA's jurisdiction to entertain the dismissal claim.
Just building on that, I'm just curious. I mean, you mentioned this dominant impression test and, what there were specific aspects that you believe the commissioner overlooked. So what do you think these specific aspects the commissioner overlooked in this case?
As set out in the Code of Good Practice, who is an employee? For example, these drivers are required to make themselves available during the operating hours, the store to which they are allocated at, for the purposes of ensuring that deliveries take place if and when required. So there's a strong argument that the hours of work are thus regulated by virtue of the operating hours of that particular store. Secondly, these drivers are given the motor vehicle or a motorbike the use for the purposes of deliveries. A genuine independent contractor will come with his or her own tools. The application of the app that is being used by these drivers are also provided to them. Their rate of pay are set by the company and not themselves. All of those are indicators. If one were to apply the Code of Good Practice, who is an employee, all of those indicators would indicate that these workers are indeed employees and not independent contractors.
How does this, this decision, this award, how does this reflect the current state of law regarding who is an employee in the gig economy?
So our current labor laws are premised on the standard, which is becoming more and more outdated. Employment relationship where a worker is directly employed by a company, and that employment relationship endures for a number of years. Now, we all know that such forms of employment, while it is still in existence, is becoming a rarity. The gig economy including sectors such as food delivery and similar services, has transitioned from an emerging trend to becoming a significant component of the labor market. And workers in these sectors, alongside other non-standard and informal workers, often fall outside the protection provided by labor legislation.
These kind of issues are constantly going to be occurring if significant changes or amendments aren't made to the current labor laws. Are there any other jurisdictions, in your opinion, that have successfully adapted their labor laws to include gig economy workers that, in your opinion, South Africa could actually learn from?
There are indeed many jurisdictions. ILO, Committee on Freedom of Association, for example, recognize under Article 87 or Convention 87, Article 2 thereof, that workers without distinction can form organizations of their choice. Now, South Africa, in that context, I would argue, is not in compliance with Convention 87, even though we have ratified that particular convention. And in as much as Article 2 of Convention 87 speaks to the right to organize, that is a step in the right direction, where workers in the gig economy and other forms of workers in non-standard employment can at least begin to have a voice to speak on their behalf. Coming back to your question around jurisdiction, our neighbor, Zimbabwe, their legislation allows for worker representation within the workplace, and worker committees to be established. There are indeed many other examples, many parts of the world that either moved to recognize the rights of workers to enjoy protection. We know, for example, that the UK Supreme Court ruled that Uber drivers are akin to a worker. So in as much as they do not enjoy the full rights of an employee, there certainly has been a move to recognize workers engaged in non-standard employment deserving of some form of labor rights.
Do you think labor laws could actually be amended to actually recognize another category of work? I mean, we have independent, we have your employees, but what about recognizing another category? And I'm just spitballing here, but what about this idea of a dependent contractor? And I'm just basing that off what you said, someone who is not a traditional employee, so to speak, but they're still entitled to certain basic protections. So this could even be things like, right to unionize or right to minimum wage and, UIF, Unemployment Insurance Fund, maybe a direction that South Africa could look towards? Do you think this is something that would work? Do you think that something like this is possible?
More than it is being possible, it is needed. The point I was making earlier is that the current construct of our labor law is based on the standard employment relationship. That standard employment relationship is being diminished on a daily basis. And the sooner we begin to recognize that there's been a fundamental shift in how work is being conducted, we must equally then recognize that labor law must follow that particular trend. You will know that it is Otto Friend who argued that labor law serves as an equilibrium between the power of employers on the one hand and obviously the vulnerability of workers on the other hand. So labor law is meant to be that buffer, if one can call it as such, to ensure that the exploitation of workers, the exploitation of labor is in some way mediated by labor rights that workers should be enjoying.
That's spot on. The idea that labor law is supposed to be this buffer, and this is exactly what our law should actually be working towards. There's still so much to be done. Taking into account what we've just discussed and also looking at the InArthur case in particular, what are the key implications of the InArthur case for independent contractors and companies in the gig economy?
For workers like InArthur, it means that the expectation of having some form of employment rights and protection is an illusion. Companies operating in the gig economy would view the InArthur versus RTT arbitration award as a major victory, because it allows them to continue contracting work in this manner and thereby exonerating them of any liability and adherence to workers' rights as provided for in our labor law. As much as the Basic Conditions of Employment Act sets out minimum employment conditions like hours of work, rest periods, etc., it does not apply to those that are deemed to be independent contractors. Now, you made the point earlier around dependent contractors and independent contractors. And the sooner we recognize one that an independent contractor is one who sells his or her labor in the open market. That person is genuinely an independent contractor. When you sell your labor or services to only one employer or one entity, you then become a dependent contractor by virtue of that contracting arrangement. And we need to recognize that there is that difference between an independent contractor, properly speaking, and a contractor that is dependent on another entity as a means of generating an income.
You're listening to the Labour Justice Barometer, and we'll be right back. For anyone listening to this that might think, okay, I have an employee or I am an independent contractor by, nature, but I'm also somebody who might look into this profession. What do you think would be the first step in extending these basic employment rights to independent contractors, particularly in the gig economy?
The first point that must be made should be the recognition that stakeholders at the level of the National Economic Development and Labour Council, NEDLAC, which is the peak social dialogue institution in South Africa, where organized business, organized labor, government, and by extension also civil society organizations get together to propose new legislation that should become applicable in the world of work. So there must be that recognition that parties are currently engaged in dialogue around amendments to the existing labor law, and those amendments include extending labor rights or labor protection to workers in non-standard employment relations, including the those classified to operate within the gig economy. So I think it's only proper that one give that recognition. The first point, as an example as to what could be done in order to ensure that labor protection indeed takes some form of realization for such categories of workers, is the point I made earlier. You simply need to go and look at the findings of the Freedom of Association Committee of the ILO. Without exception, they've consistently ruled that states need to amend the legislation to allow workers the right to join associations of their choice. Whether those are independent contractors, even those we identify as genuine independent contractors, dependent contractors in the manner we've clarified it now, or however workers are indeed classified. The right to organize, the right to associate is something that is provided for under Convention 87, in particular Article 2, and our labor laws should facilitate the right of workers to join and form trade unions or similar organizations, and not, as per the Labor Relations Act, employees having that right. So I think that in the first instance will go a long way to ensure that workers certainly have a voice, and in exercising that voice, the right to collectively get together and ensure that their rights are indeed recognized.
Thinking about it now, something we like to ask on the podcast is, on a labor justice scale, because that's what this podcast is all about, how does this case measure up for you?
There can be little doubt that the CCMA, as a labor dispute resolution institution, has been very effective in the speedy resolution of labor disputes. Having said that, in recent times, the CCMA has started experiencing challenges of budget cuts, while at the same time assuming an increase in the nature of disputes being referred to the CCMA. For example, disputes relating to either short or non-payment of the national minimum wage, something that the CCMA never previously had to consider. In the absence of having done empirical research to suggest that the InArthur versus RTT arbitration award was influenced by factors like an expansion of the CCMA's mandate or the impact of the budget cuts the CCMA is currently experiencing. But at the very least, we would expect CCMA commissioners being schooled in labor law to apply the law, including the various codes of good practice that is issued by NEDLAC from time to time. In so doing, we will see the genuine application of social justice in the employment context. I think that the InArthur versus RTT arbitration award falls short in that respect, meaning that I'm convinced that if that commissioner had properly applied the code of good practice on who is an employee, looking at Section 200 capital A of the Labour Relations Act, based on the merits of the case, that commissioner would have come to a conclusion that Arthur is indeed an employee as opposed to an independent contractor, and then consider the basis of his unfair dismissal.
I mean, like we said, we don't get all the facts that are presented to us, but obviously looking at the arbitration award and, agreeing that the CCMA, they do deal with a lot. They are obviously overburdened with a lot of cases. What would need to be required is probably this idea of a more nuanced interpretation of the employment relationship, thing that can better result in reflecting the realities faced by gig workers, considering maybe the broader social and economic context of gig work rather than strict contractual terms. Just leading off to that, what precedent does the Arthur Award set for future disputes involving gig workers? And how do you think this might shape labor justice, especially in the gig economy?
The Arthur versus RTT Arbitration Award itself does not set a precedent. As another CCMA commissioner may come to a different conclusion, and I'm sure, as I previously said, I'm almost certain that another commissioner would have come to a different conclusion if he or she had applied the code of good practice on who is an employee. It would have been interesting to see the reasoning of the Labour Court if the arbitration award was taken under review. Arthur, in the situation, being a precarious worker, obviously with no assistance whatsoever, never, I would argue, even had the financial means to take the arbitration award under review. So, that obviously deprived the Labour Court from having entertained that kind of a dispute. And it would have been interesting to see how the Labour Court would have reasoned as to whether Arthur is indeed an employee or an independent contractor. From my own reading, I am satisfied that the Labour Court, certainly I'm of the opinion that the Labour Court would have concluded that Arthur was indeed an employee. The court would not have been able to consider his claim for unfair dismissal, because when the CCMA commissioner ruled in a preliminary ruling or point preliminary ruling that he is not an employee, that was the end of the matter. As things stand, an employer can rely on the Arthur versus RTT arbitration award to persuade another CCMA commissioner to rule along the same lines. The doctrine of precedent in South Africa dictates that a CCMA commissioner must rule similarly to a higher body, being the Labour Court, Labour Appeal Court, or the Constitutional Court. But an arbitration award can be persuasive in terms of another commissioner considering something on the same set of facts. The trade union movement or other forms of worker organizations, they will have to act on long-standing resolutions to organize workers in the gig economy to bring about some form of social justice. Only then might we see some form of enjoyment of workers' rights for those working in the gig economy. Again, making the example of Arthur versus RTT, you had Arthur being a precarious worker, going to the CCMA, challenging an unfair dismissal claim. He was representing himself. He had no right to join a trade union because unless you are an employee, you're not allowed to be a member of a trade union. The employer, RTT, was represented by someone from an employee association. I would argue is a lack of social justice insofar as the application of one labour law and also the protection that labour law should be providing.
That basically summarizes everything and shows that, obviously this is a 2021 award, and, this, if it had to be brought on review, it would have been a great issue to actually bring to the higher courts, because as more and more gig workers seek to challenge their employment statuses, I think if this was escalated to the Labour Court or even Constitutional Court, I think it could lead to landmark decisions or rulings that just redefine the whole legal landscape for gig workers. And I think it just reinforces that the current classifications that we have, where gig workers are independent contractors, I think it will allow the law to actually push for broader protections and rights, and it can allow outcomes of awards like this to significantly impact the gig economy in a positive way that allows for, labor justice in South Africa. And I think that's just, again, it starts with arbitrations awards, and it shows how cases like Arthur's is not a new one. It hasn't changed significantly since. Yes, there have been some significant shifts, but there's still a call that there needs to be, this reinforcement of pushing for broader protections and rights, and realizing this as companies and the digital economy shifts and progresses. So to sum that up, I just wanted to say thank you so much, Mario, for sharing your thoughts today and for joining us on the podcast and giving us such an informative discussion on this case, on this award. And, for those who haven't actually read the Arthur Award or are not familiar with what happened in Arthur versus RTT, we will be leaving links to the actual award and obviously links to Mario's research in our podcast description so that you can follow all the work that Mario is going to be undertaking at CENTROW. Thank you very much, Mario, for joining us, and we hope to have you back on the podcast soon.
Thank you, Aisha. It certainly has been a pleasure engaging on a critical piece of almost absence of law in the current period, something that I'm hoping that the NEDLAC stakeholders will correct as a matter of urgency. But thank you.
This podcast is not intended to constitute legal advice.